Good afternoon, everyone. This is Tim Fuchs from the National Council on Independent Living here in Washington, D.C., and I want to welcome you all back for the final episode of CILNet's Strategic Management Series. Of course, today's final presentation is Managing Workplace Risks. This series is being presented by the CILNet, a program of the ILNet Training and Technical Assistance Project for CILs and CILCs. The ILNet is operated through a partnership among the Independent Living Research Utilization Program, ILRU, in Houston, Texas, the National Council on Independent Living, or NICL, here in Washington, D.C., and the Association of Programs for Rural Independent Living, or APRIL, in Little Rock, Arkansas. And the program is run with support provided by RSA at the U.S. Department of Education. I want to welcome back Melanie one last time. Melanie's done a fantastic job with our series. Again, she's the Executive Director of the Nonprofit Risk Management Center in Leesburg, Virginia. And Melanie, thanks so much for being with us, and we're excited to hear about managing workplace risk.
Thank you so much, Tim. It's my pleasure to be the presenter for this final program in our series. And what I thought I'd do at just the outset is to let everybody know that we're going to begin with a short primer on risk management, talk a little bit about risk and risk management, and then we're going to move into a discussion of some basic workplace rules, things that I want you to keep in mind. And then we're going to turn our attention to some special topics in workplace risks and workplace safety. We're going to talk about sexual harassment, other forms of harassment, workplace bullying, and workplace violence. So let's start with that very brief, I promise, primer on risk and risk management. So let's talk about the issue of risk, the topic of risk. When we think about risk in an organization, we're really talking about or referring to uncertainty about events and how we really don't have the ability to predict the future, to forecast with any degree of perfection or certainty the future, and therefore we're always operating in an environment where we're never quite certain what might occur. And what risk management is all about is being prepared for a wide range of possibilities. Now, some of the aspects of uncertainty that exist in organizational life include uncertainty surrounding operational performance, whether or not your organization is going to be able to achieve its ambitious goals and objectives. And, of course, the final area of uncertainty that seems to be a big cloud for many organizations and causes lots of concern is whether we will meet the expectations of our stakeholders. And we're becoming more and more familiar with the range of stakeholders that support our organizations, and it's important that you're always trying to get a deeper understanding of what those expectations are so you're taking steps to meet those expectations. But the bottom line here is that there's lots of uncertainty and therefore lots of risk with respect to running an organization in this day and age. On the next slide, I chose to give you what I consider to be the most basic definition of risk management. And as you can see, this is not a definition that is academic in any way, shape, or form. The definition is simply a discipline for dealing with uncertainty. And that's really how I think about risk management and how we approach it at the Nonprofit Risk Management Center and how we try to teach leaders about risk management. We say that basically the world is an uncertain place, that not only the organizations we run and work in have elements of uncertainty, but the world that surrounds us is uncertain as well. And we have to deal with both of those dimensions. We have to deal with things within our control, things that we can control and influence. And we also need to be prepared for and we're able to respond to things that are outside our control, that are happening out in the environment that may affect our ability to deliver our mission or to provide the services that we've agreed to provide, that are part of our mission, or that we're contractually obligated to provide. So let's continue this discussion of what we mean when we talk about risk management. So I've given you on this next slide 3 very basic examples of risk management, and this isn't intended to show the spectrum of what I mean by managing risk or risk management, but just intended to offer up some food for thought as we proceed. The first example is the idea of creating rules that explain to individuals what we expect or what we require, what we absolutely prohibit, and also what consequences apply. So one of the things I noticed in working with many different types of organizations, different missions and in different locations and different clientele, is that organizations understand, the leaders of organizations basically understand that you need rules, right? And the smaller an organization is, the fewer rules it will probably have. And as organizations get larger, they tend to adopt more and more rules and policies. Well, one of the things that also happens is as an organization gets larger and more complex and requires additional rules and policies, one of the mistakes that we often make is we fail to go back and take a look at those policies that are in place and determine whether or not they need to be updated or changed, whether circumstances have changed or such that the policy is no longer applicable or is no longer consistent with how we're actually operating. And so policies tend to get stale, and we need to make a commitment as leaders to go back and revisit old existing policies and update them as needed. So that's my first example of risk management. Another example is in the second bullet point, and this is a more kind of a hands-on example of risk management, and that would be rehearsing a plan for evacuating our staff and clients from a particular facility in the middle of an emergency. So good risk management is not only about having policies and procedures in place, but it's also about having the skills to do certain things and having the confidence that we're able to do certain things, and certainly having the confidence that you would be able to safely evacuate personnel in the event of emergency is an important risk management capability. And then the third example I've given is the idea of anticipating how an organization might spend an unexpected donation. So that's a great example of an upside risk, something turning out better than we would expect or better than we had planned for. But having a plan as to how that resource, that unexpected gift or resource would be spent before we actually receive the gift. That's a good example of risk management, even though it's contrary to the typical perception of what risk management is about. Most of us, when we hear the term risk management, we think about downside risks. And then in this final bullet, I also included, really the opposite of the first part of the bullet, which is the possibility of having to cut costs if our revenues fall short of expectations. So planning ahead, coming up with a contingency plan, a plan B, is another example of risk management. So what I tried to do in this particular slide was just to give you examples of the practice of risk management which occurs in organizations every day and across the country, and just give you examples to illustrate that it's not a discipline that's all about only rules or only about safety equipment or only about safety drills, only about screening processes and such, but it really is a very broad discipline that covers lots of different areas. I'll give you a little bit of a flavor for what we're talking about when we use the terminology risk management. Now let's turn our attention to this topic of key workplace rules and protocols. And again, the topic for today's program is workplace risks. And of course, there's so many different risks that arise in the operation of an organization and operation of any agency. And of course, some of those risks occur outside the workplace, but others really impact mostly the workplace. And that's what we're focusing on. So my first piece of advice that appears on the slide in front of us is the fact that it's really important that your staff, that the personnel who are managing activities and operations on a day-to-day basis, have a very clear understanding of what you permit, what you encourage, and what you require. They need to have a clear understanding. Is what I'm doing permitted, encouraged, or required? Is this something I must do? Is this something I should do? Or is this something that I can do, I have the option, I have some discretion? And, of course, they also need to know if there are certain things you discourage or if there are things that are strictly prohibited. And one of the things that I noticed in talking to leaders who are having difficulty with their staff, who are having challenges with staff doing what they're supposed to be doing and working effectively, is that there often seems to be this disconnect between what the organization requires and what an employee is doing. And when you ask the employee about the issue, the employee sometimes says, I didn't know. I did not know I wasn't supposed to do that. Or I didn't know that I had to do that it was vital that I do that. It didn't seem so serious to me because it was on page 33 of an employee handbook. Or that was not mentioned to me during my orientation. Or I didn't know that was my responsibility because it's not listed on my job description. So these are things or excuses or comments that I've heard from staff over the years from many different types of employers. And I would imagine all of those on the call today who've got a lot of experience as supervisors have heard comments like these over and over again over the years. The basic comment or the way the comment begins is, I didn't know. I didn't know. And so what that's telling us as leaders of organizations is that we need to do a better job of letting our staff know, helping them understand, and certainly helping them understand the most critical issues, those things that are absolutely required and necessary to protect the organization's mission and its assets and the safety of everybody involved. And what are some things that are absolutely prohibited? That if one were to do one of these things that's prohibited, your job is on the line, and you know that well in advance. All right, the second point I wanted to make on this slide is that your critical rules and policies need to be written down, and need to be written down in a language that your employees will understand. And not just your management employees, or not just your employees with advanced training or higher levels of education, but your rules and policies need to be written in language that every employee can understand. And one of the things I've noticed over the years is that some of the groups I work with seem to be drawn to using the term, we use the term legalese to refer to language that seems to be overly complex or it appears that it has some sort of legal value or worth, that it's written in a style that's quite formal. Many organizations seem to be drawn to that language, and I think it is out of a belief that if very legalistic language is used, it's more likely to be enforceable, or it has greater weight if it's very formal. And I think the opposite is true. I think that the reality is that if language is so complex and confusing and hard to understand, then it's probably more likely to be interpreted, or there's a possibility it could be interpreted in several ways. And if it's able to be interpreted in several ways, then it might not be enforceable after all. So you kind of do yourself a disservice if you use language that's very bureaucratic or formal, or it would be interpreted as legalese. And the result is that people don't understand your policies and procedures, and of course if they don't understand, they're in a really tough spot in terms of trying to follow and comply. So the bottom point really emphasizes that, which is that your rules and policies actually are of little benefit and can hurt you if they are very long or voluminous, if they're hard to find, if you've hidden them somewhere on a file server and somebody has to search your network for them, or if they're so vague or complicated that they're easily misunderstood. So the intent of this slide really was just to remind you about some very basic concepts in terms of developing workplace rules and policies. All right, on our next slide, I wanted to go over 3 tips for improving the value of the workplace rules that you already have in place, or perhaps the workplace rules that you hope to continue to develop. The first tip is make certain that you take the time to explain why the policy is important, or why the rule is essential, why it's being put in place in the first instance, and not simply what. And I offer this tip because I've seen over the years organizations that put all of their emphasis on coming up with new policies and rules. And I think someone imagines that if I just publish these rules and policies, if I just, tape them up on the wall of the kitchen, or I distribute them via email, or I post them on a file server, or include them in the handbook, everybody will fall into place. But the fact of the matter is, it's human nature to question new rules and policies and wonder why. Why is this policy being developed? What does it have to do with me? Is it important? Should I follow it? It's very much human nature to question new policies and procedures that seem to get in the way of what you're trying to do in an organization and your normal work. And so what we need to do as leaders of organizations is take the time to explain the reasons, the rationale for new policies and procedures. And of course, when we do that, we're going to increase the chances of buy-in and support for those policies. We're also going to increase the chance of adherence, that if someone understands why, they may be more likely to follow and support the policy. A second tip for improving the value of your workplace rules is to, in a very open and sincere way, invite comments and suggestions and ways to improve. Be sincere in asking your personnel to comment on policies and rules, and let people know that you're not casting any rules or policies in stone, and that rules and policies will change as the organization evolves, and that their input is so valuable and so important. And the way to make these rules and policies effective in terms of protecting the organization and protecting them as well is to make certain that these rules and policies are understood and followed. But there's no question that many of your rules and policies will evolve over time, and much of that evolution will be the direct result of feedback that you receive from your employees. A third tip is to take some time to go back to your workplace rules and policies and try to identify those that may be hard to understand, those that are perhaps worded in a convoluted way, that are overly complex. So first try to identify those that are hard to understand, that for which somebody may have different interpretations. So one employee may interpret it this way, and another employee may interpret it another way. Also look for policies that are hard to follow. Policies that are so complex that it's hard to get it all right, to jump through all the hoops that the policy requires. And then the third idea here is to try to identify one or more policies that are commonly or occasionally violated. So one of the things I've done over the years is when I go to meet with staff in an organization, if we're in the middle of some sort of assessment, I will always ask the people that I'm interviewing to identify for me one workplace rule that's being violated or that is commonly violated. And in my experience, I found that every employee I speak to is typically able to identify at least one workplace rule that has been written down somewhere, is included in some set of policies, but is typically or commonly violated. And so what I try to do is go back to the management team and let them know, that here's a list of rules that from your employees' perspective are commonly violated. So when you identify those policies that are hard to understand or hard to follow or commonly violated, there are three possible courses of action that you can take. The first course of action is to eliminate policies that you've decided are no longer applicable or necessary to the agency. There may be some policies that are very dated and simply are of little value and don't help you advance your mission and therefore can be eliminated, and you want to go through the proper steps to do that. A second option is to change policies that aren't working, change policies that are hard to understand, rewrite them in simpler language so that everybody in your agency is able to understand them. So you can eliminate policies that aren't working or poorly understood or hard to understand. You can change policies that aren't working or hard to understand or are commonly violated to make them more easier to follow. Or the third option is you can commit to holding people accountable. So if you've got policies that still make sense, that are well written, that are written in plain language, that are easily understood, but people are just ignoring that policy, and if that policy is still vital to your agency, to protecting your agency's assets and mission, then you need to start holding people accountable. So you always have options here, but it's always a good idea to kind of go back and take a look at some of those policies that have existed for some time and try to identify areas where you might make some improvements going forward. We're now going to turn our attention to that list of special topics that I mentioned at the outset, and you see them listed on the slide. We're going to start with a discussion of sexual harassment. We're going to move into other forms of harassment and some suggestions for addressing that exposure. And then we're going to wrap up by talking about workplace bullying and workplace violence. So the first topic in this list is sexual harassment. Well, as I think everybody on the call knows, sexual harassment really undermines the integrity of the employment relationship. And in some respects, it compromises equal employment opportunity. It most certainly harms morale in the workplace. And there have been studies about workplace misconduct that have shown repeatedly that misconduct and harassment interfere with productivity. I mean, when you harm morale, when you take action or permit action to occur that makes employees feel less valued or makes them feel threatened, their commitment to the organization wanes, and the energy they have, their ability to contribute to the organization in an enthusiastic and productive way, declines. So there are so many different negative consequences of sexual harassment, not only the commission of some act of sexual harassment, but an organization permitting it to occur and not taking action. That this really is a serious subject that warrants our attention. And, of course, it's against the law to permit sexual harassment in an organization. So one of the first tools that an organization should have in place to manage the risk of sexual harassment is to have a policy that prohibits sexual harassment. And so in this slide, you're seeing the 5 key components of a policy that prohibits sexual harassment. The first component is a zero tolerance for sexual harassment, a clear statement indicating that the organization does not permit any sexual harassment committed by or against employees. A second component of that policy should be a statement indicating that when somebody brings forward a report of sexual harassment, either harassment they have experienced or they have witnessed others experiencing, that they're not going to be subject to any retaliation, so they're not going to suffer the risk of a demotion or other retaliation simply for coming forward with a truthful report of sexual harassment. And, of course, there's going to be no retaliation if someone cooperates with an investigation related to sexual harassment. So you certainly want to encourage employees to fully cooperate and be truthful and candid should you have to undertake any investigation as a follow-up to reports of sexual harassment. Another key component of a policy is a commitment to promptly report inappropriate conduct, in that you need to know if inappropriate conduct is taking place in order to provide the safe environment and to provide an appropriate environment for your employees. So you want to convey the idea that if an employee withholds information and doesn't come forward, they're actually not only hurting themselves, but they're hurting the entire organization and making it very hard for leadership to enforce this important policy. And, of course, another key component, I've listed it as number 5 on this slide, is that you want to convey the idea that an employee who violates the organization's rules with respect to sexual harassment is subject to disciplinary action, and that could be quite severe and could include, of course, termination from employment. There are 2 types of sexual harassment. I want to talk about each of these, so we have separate slides. The 2 major categories are known as quid pro quo harassment and hostile work environment. So we're not going to spend a whole lot of time on this, but I just want to give you a quick overview of the differences between these 2 types of harassment. So quid pro quo refers to something for something. And when we talk about quid pro quo sexual harassment, we're really talking about instances where submission to sexual conduct or sexual contact is made a term or condition of employment. So in order to work here, you must do as follows. Or if it's not stated so explicitly, it might be implicitly, such as, you know what you need to do in order to keep your job. Or if you have any hopes of getting a promotion, you know what you need to do. So those sort of implicit references or explicit references where one needs to perform certain sexual activities or be involved in a sexual relationship or submit in some way in order to keep one's job, receive a promotion, etc., or avoid termination, perhaps. And another way to look at quid pro quo harassment is the idea that someone is that submission to or rejection of any sexual conduct is basically used as a basis for employment decisions. So somebody in a position of authority who's deciding who to promote says, well, I'm going to pick this person over that person because of our sexual relationship, that has given them somehow an advantage. Now, as you might guess, quid pro quo harassment is pretty rare in organizational life these days, and it's not the most common form of harassment, and in fact, if you look at the claims alleging sexual harassment in an organization, it's the lesser of the 2. It's the rarer of the 2. The second form of sexual harassment, which is becoming better known and where I think the majority of the claims occur, is in the area of hostile work environment harassment. And this can be both, could be sexual harassment or conduct, abusive conduct or offensive conduct, and it certainly does not require physical contact between two individuals. And the idea behind hostile work environment is not just an environment where every once in a while something makes you slightly uncomfortable. A hostile work environment exists where conduct is severe or pervasive. And it's got to be severe or pervasive enough to make a reasonable person of that harassed employees believe that somehow the conditions of employment have changed or the environment itself has become hostile or abusive. So there's no question in looking at cases alleging hostile work environment harassment that we're not talking about one-time incidents or minor slights or, a moment of discomfort, but we really are talking about pervasive conduct. Now, having said that, somebody's conduct could be so egregious in one instance to constitute hostile work environment harassment. So I don't want you to think that if harassing activity, has only occurred one time, then there's no way that it could be actionable. It's not necessarily true, but it would have to be very severe. And I think it's good just to look at the word severe or pervasive. Either it's ongoing and consistent and really serious, or it's severe. And severe could be a one-time, but very major incident. All right, we're going to turn our attention now to the idea of a broader risk of harassment and thinking about the idea of preventing harassment in the workplace in a broader sense. And what I would encourage you to do in your agency is to take a second look at your policy prohibiting sexual harassment and consider whether a broader definition, a broader prohibition might be in order. And so in this particular definition, the example that I'm giving you on the slide in front of us, it says the term harassment includes sexual and racial harassment, as well as harassment based on any other protected classifications, such as color, sex, sexual orientation, religion, ethnic heritage, mental or physical disability, age, and or appearance. So this definition says, look, this organization prohibits harassment, and we're not talking just about harassment based on sex. We're talking about harassment based on all of these other protected characteristics. And then this definition includes an additional expanded description of what we refer to by sexual harassment. So every organization really has to come up with its own policy prohibiting harassment, and many employers continue to simply have a policy prohibiting sexual harassment, but I do think that it's time for employers to take a second look at this and consider a policy that is broader and includes other forms of harassment as well. Now, we're continuing on the slide in front of you with this definition, this sample broader definition of prohibited harassment. And in my sample, I've included examples of actions that may be considered harassment, and I've broken it down into two different categories. One of the things we've learned from looking at cases on harassment, claims alleging harassment, is that for a policy to be effective and understood, it needs to explain in pretty clear terms what we're talking about, because the fact of the matter is that employees in the workplace today don't have a shared understanding of what prohibited harassment is exactly. So it is helpful to spell it out, and what we've tried to do with this sample policy is really spell it out for you. So you can see on the slide we've got some additional information on what we mean by verbal harassment, or what do we mean by physical harassment. And just, again, trying to break it down and give additional information to spell it out. Now, on the next slide, we're continuing with this sample broad policy prohibiting harassment, and the language on this slide actually gets us into another area, even broader in scope than prohibiting harassment based on your participation or membership in various protected classes. this definition, or this component of the definition, says that harassment of any employee, volunteer, client, or vendor is prohibited. So we're actually delving into the world of what's called third-party harassment, where the victim or the perpetrator may be someone who's not even an employee of the agency. And in this sample, we're saying that we prohibit harassment against a vendor, a third party committed by one of our employees, or harassment of an employee perhaps by a third party as well. So we're really extending the boundaries of the anti-harassment policy to a very broad scope. And I think in this day and age, it's important to do so. And also, there certainly have been claims over the years by third parties, and organizations have been found legally responsible for harassment suffered by third parties at the hands of their employees, or harassment suffered by their employees at the hands of third parties. So it is important to think a little bit more broadly about providing that safe workplace, that appropriate workplace. Now, again, this policy includes language that's consistent with those 5 components that I spoke of a few minutes ago, and it reminds individuals that individuals who violate this policy are subject to disciplinary action. And this policy sample includes the language at the discretion of the executive director. So again, it emphasizes the idea that management has discretion in applying this policy, and that the disciplinary action is not limited to, includes but is not limited to termination. So the potential disciplinary action could be quite severe. This sample includes the following language: clients or vendors who violate this policy will be subject to disciplinary action or other measures at the discretion of the executive director, including but not limited to ineligibility for services or termination of the organization's relationship with the vendor. So again, this is recognizing the fact that if you've got a vendor or client, you can't terminate them in the way that you could terminate an employee, but there may be other action that you can take. And then the last bullet point on this slide just reminds us that prompt reporting of inappropriate conduct is essential to implementing this policy. And, of course, your organization is going to be urging all employees to report policy violations. You know, your employees are the eyes and ears of the organization and really are necessary. Their cooperation, their support, their participation is necessary for you to uncover acts of harassment for which action would be required and important. All right, we're continuing with our sample of this very broadly written anti-harassment policy. And on the slide in front of you, the very first statement says, no employee who makes a good faith allegation of harassment will be subject to retaliation. And this is giving a very strong message that if you report your belief that somebody has been harassed or subject to harassing action, or you yourself have been victimized, you are not going to be retaliated against. We're not going to take action against you for reporting because we want to know. We want to know. And, of course, we use the language good faith allegation because we don't want employees to feel that they can come to us with made-up stories, you know, as their own form of revenge or retaliation against a coworker. So we don't want to encourage people to make things up. We want them to know that there will be no retaliation if they make a good faith allegation. Now, the implication in this language, of course, is that if one makes a false allegation, a knowingly false allegation, then one is subject to retaliation. Then one could be terminated for making a false, a knowingly false allegation. And that second bullet point really emphasizes that. Any employee or volunteer who knowingly makes false allegations will be subject to disciplinary action at the discretion of the executive director. Now, the term discretion of the executive director, you know, means different things to different people. And basically what that means to me is that this individual, and this policy may not be suitable for your organization, so this is just a sample to consider. But what this language means to me is that the executive director or the head of administration or whoever has this authority basically can look at the facts at hand, can weigh the facts at hand, listen to various sides of the story, and decide what punishment, what discipline is appropriate in that instance. And somebody who makes an offhand comment that is offensive, you know, the appropriate discipline in that instance may be an apology to the person they made the comment to. So some acts that would be perceived as harassing or inappropriate may warrant an apology, a verbal apology, a written apology, or some other follow-up. But there may be some actions that are just so egregious that they require suspension, that they require that somebody be removed from the workplace so they fully understand the seriousness of their actions and its effect on the individual in question. So, the discretion of the executive director is really referring to the fact that somebody in the organization who has to decide what action will be taken has some discretion, that you're not going to come up with a list of actions and corresponding punishments. It's not like the criminal justice system where, we've codified the terms that would be served for committing certain crimes. In this type of situation, in terms of managing the risk of workplace harassment, I think it's important that someone has discretion, because it's pretty unlikely that you're going to be able to predict with any degree of accuracy exactly what type of harassing act is likely to occur and who's going to commit it and what are the circumstances and how it's going to be interpreted. And something else to consider is the fact that somebody in the organization could make the same statement to two people. One person could find it amusing or interesting or non-consequential, and somebody else could be deeply offended. So people interpret remarks and conduct very differently. And so that makes it very hard for you to decide in advance what the discipline ought to be for various offenses. All right, we're back to the idea of what is workplace harassment. And this is language that also really is part of a sample policy, and in some cases is incorporated in a broad anti-harassment policy, a written policy that you would provide for your employees. And it basically just reminds us that an individual's actions may be considered harassment if they create an intimidating, offensive, or hostile environment, if they interfere with performance, or they adversely impacted employees' employment opportunities. So this is, again, quite broad language and just gives us some insights in the types of effects that we might expect from inappropriate action. All right, now we're turning our attention to the idea of managing harassment risk, and I've offered just a few tips for your consideration. The first is that you take the risk seriously, and by this I really mean that we can't stop at just adopting an anti-harassment policy. Many organizations say, well, look, the main thing or the main way to prevent harassment in the workplace is to have something in writing saying you're not supposed to do that. And I think that is an important first step and a starting point, but it's certainly not the end point. And you need to find ways to make that anti-harassment policy real. If you have a policy in place and it's not followed, you don't follow up on complaints that you receive, or if you do follow up, you never take any action, you just dismiss them, over time, the policy will not be taken seriously. And I'm sure you can perhaps think of other examples of policies that are in place in your current workplace or in other places where you've worked, where the policy was in name only. It was committed to writing, but it really wasn't followed on a regular, consistent basis. Another tip for managing harassment risk is just to urge you to try to think in a broader fashion than traditional, more narrow sexual harassment committed by employees. That's typically where most of us begin, is to prohibit harassment by employees. But I also want you to be aware of the risk of third-party harassment claims. And I alluded to that a little bit earlier when I talked about the potential claimants and also victims being persons other than employees. But third-party harassment claims refers to situations where a non-employee harasses an employee. So that could be something such as a board member harassing an employee, or a vendor, contract personnel harassing an employee. Third-party harassment also occurs when an employee of yours harasses a non-employee. And you can also have third-party harassment claims where a hostile environment is created or exists due to the relationship of other employees. So, for example, you could have a hostile environment or a third-party harassment claim where one employee, so say this person is working in the finance department, And this employee feels that a hostile environment has been created by the fact that her coworker, another accounting staff member, another finance person, is having a relationship with the head of the agency or with the chief financial officer. So third-party harassment can be both where you feel the effects of harassment even though you have not been, no action has been directed at you, so you've not been subject to any harassing conduct, but you feel the effects of this sexual harassment in the workplace. It creates a hostile work environment, so that's a form of third-party harassment. Or third-party harassment exists where a third party, not an employee, is either the perpetrator or the victim. So it's an interesting area. It's an evolving area of the law, and we are seeing that some employers are being held responsible. But the way you approach it has to be a little bit different. So in terms of risk management strategies, that was my third topic for this slide. I think it's important that you do have a very clear and plainly written policy prohibiting harassment. I would hope that if you don't already have a policy that's broadly written as to prohibit lots of different forms of harassment, that you consider broadening your policy. I would also ask that you need to provide some training in that policy, and also take a look at your reporting procedures. How are people encouraged to report, and how do you handle complaints? I just want to pause to take a couple of the questions that have come in via the chat feature. The first one I tried to address early, which was, why would it be at the discretion of the executive director? Why would you even permit discretion? Well, there are two forms of thought with this. One is that discipline should be prescribed so that everybody knows in advance, if I do this, the following discipline will be applied. And we all like a roadmap to our destination, right? We all want to know where we're going and how to get there. And so that prescribed form of personnel policy is very popular, and in some ways it's comforting for employees who know exactly what they can expect if they commit a certain act or they fail to do something. But on the other hand, the downside of that prescribed action approach is that so many things happen in the workplace that are hard to predict, and it's hard to predict the way in which things will occur. And so really great workplaces and great leaders are those that can figure out how to apply the appropriate discipline or take the appropriate action based on what actually has occurred, the circumstances at hand. And so I do believe that heads of agencies should have discretion to take action as appropriate. And in a large agency, this would include not just the executive director, but may also include other people with supervisory responsibility. And that's because we need to take action based on what's actually happened, and following some prescriptive list of this is what happens if you do the following things or commit the following offenses kind of ties the hands of management to truly exercise that judgment and flexibility that's part of being management in an organization. The second question from the chat that I thought I would take at this point is, do you need to disclose the policy to third parties? And if so, how do you suggest doing this? Well, that's a really interesting question. So basically the question comes out of my comments about the idea of broadening your anti-harassment policy to include third-party harassment, telling your employees that they may not commit acts of harassment against third parties, nor will you permit, if you have any knowledge, them to suffer harassment at the hands of third parties. My take on this is that having a policy like this in place does not require that you share this policy with third parties, although there may be limited instances where it makes sense to do so. So, for example, if you're contracting with another provider and that provider is going to send employees to work in your workplace, you might put in your contract some reference to this policy. You might reference that you have a broadly worded anti-harassment policy that prohibits sexual harassment, other forms of harassment, including first-party as well as third-party harassment. So you might put your contractors on notice in that fashion. But for the most part, I don't think you're required to or expected to, or it's really realistic for you to notify every contractor that you do business with, because let's face it, we do business on an ongoing basis with probably a handful of contractors, but there are many others that, may come in to deliver packages or show up to provide short-term services. And I think it would be very hard to notify or put on notice all of these different contractors. So the approach here is that even if you haven't put those organizations on notice, what you've got to be concerned about is what you do if you receive a complaint or notice that some form of harassment has occurred. So, for example, if you receive a call from a third party, from a contractor, from another organization saying that one of your employees has harassed inappropriately one of their employees or one of their volunteers, I would urge you to treat that as an incident. Treat it as if one of your employees has done something and look into it and investigate and do the best you can to confirm or deny the allegations. And if you are satisfied that your employee did commit an act of inappropriate harassment against a third party, you have the ability to discipline that employee even though the victim is outside the organization. So that's the approach if the harassment is going in that direction, that your employee is the perpetrator. Well, the approach if your employee is the victim, if you have an employee who comes to you and says, I have been harassed by a third party, by that contractor you hired to help us with finance, or by the person who was delivering a package, or by the person we hired to help us plan a meeting, my approach would be to contact the owner of that organization or a senior person at that organization and let them know that your employee has been victimized and that this is contrary to your policy, is not acceptable, and I would make a very specific request that if you believe the report to be credible and truthful, then I would make a request that contractor provide a different employee to do the work so that they not send that same person back and continue to put your employee at risk. The other thing I would do in that instance, though, is to speak to the employee who's been victimized and ask him or her, what would you like to see happen, or what ideas do you have, or suggestions that you may have as to how we can manage this risk and make certain that you're not subject to unwanted illegal harassment that's clearly in violation of our policy. So it's important to conduct an investigation, to look into the allegations, but also to check back with the employee. And there are things you can do. You certainly can't fire an employee who works for another organization. That's something you can't do. But you can request that a different assignment be made so that your employee is not going to be subject to or have to work with that individual again. So those were great questions coming from the chat. And let me turn it back over to Tim to see if we have other questions as well.
Thanks, Melanie.
What do you do with the employee if a third-party person has made a complaint against the employee? What do you do in the meantime?
Right, good question. So what do you do with an employee where you've got a complaint by that third party? Well, I think you want you want to investigate. When I use the word investigate, I don't mean, calling the police and hire a private eye. I really mean asking the people that have made the complaint and about whom the complaint has been made, asking them to explain what happened, what's going on. Tell me your side of the story. Let me hear about the circumstances. And I would listen to both the employee and I would also listen to the organization making the complaint. Now, you may not be able to talk to the individual at the contractor that's made the complaint, but you may be able to talk to their supervisor or the manager or the owner of that organization. And you also, you really need to have a conversation with the employee and make a decision, make a determination based on hearing the various sides of the story as to who's credible and if you can try to figure out, what does it sound like really happened? Did your employee do something that's completely inappropriate and is actionable harassment, is inappropriate conduct that warrants discipline? And then, of course, and if that's the case, then you should administer that discipline. And it could be anything from a warning, a reprimand, requiring that they submit some form of apology. It could be suspending their employment for some period of time. It could be termination if it's really egregious. If you believe the conduct has occurred, it's really egregious. Another option, of course, much less punitive, would be if you believe that perhaps it's just been a terrible misunderstanding and that your employee was misinterpreted or misunderstood, I would consider whether there's any opportunity to reassign another employee to work with that contractor, to get that contractor out of harm's way from their perspective and reassign. Now, some of these strategies work well in a large organization where you have lots of options. In a small organization, you may not have as many options, but you definitely can't ignore it. If you've received a complaint from a third party, you really should not ignore it. So you've got to figure out, kind of weigh the credibility and make a decision, and always tailor the action that you take to the seriousness of the offense. And if you feel like these two people can no longer work together, then you need to find another connection.
Okay.
All righty, good question.
Hi, this is Evelyn. My question is not directly related to harassment. It's just the end of the series, and I want to ask this because it's come up. So I would be glad to wait until the end if other people have questions that are more closely related to the subject.
Why don't you go ahead and ask, and let me see if it's something I can answer quickly or something that's better to get back to you on offline.
All right. This is a question about independent contractors, where you might bring someone in to do a specific job, and there has arisen a dispute about whether somebody is an independent contractor or whether that would be a wrong use of independent contractor, and whether that person should be a regular employee. And the question arose because of the amount of direction that I have to give this quote unquote independent contractor. So, and I did look on the IRS website where they talk about independent contractors, but it seems to be a bit vague in some areas, and I wondered if you could help me.
Sure. Well, that's an important question, and it's not related specifically to the topic today, but it's such a universal issue, and so many organizations struggle with this. The fact is that there is no one litmus test. So if you're providing complete and total direction for that individual, it starts to make us think or lean us in the direction of employee. But if that person is setting their own hours, if you are just one of many clients that they have or one of several clients that they have, if you're paying them for the job done and not necessarily by the hour, if they're doing a job that is not a regular function in your organization, but something you just need for one day or a short period of time during the year, then all those other things kind of counteract the evidence of their being under your close supervision. So it's not just one factor. It's a lot of different factors, and the IRS asks us to kind of weigh and balance all these different factors. And just that one issue of being closely supervised does not turn an independent contractor into an employee. That alone won't do it, but it's really the combination of factors. And so, yes, typically an independent contractor is not under very close supervision, is not told, okay, for the next hour I want you to stuff envelopes, and then I want you to type letters, and then I want you to make phone calls. Typically an independent contractor doesn't work that way. They get to decide how to approach the work that you assign them or you're hiring them to do, but that alone won't turn somebody into an employee. It would have to be other factors as well. If you're providing office space, if you're providing equipment, if they're using your database, if you're supervising them closely, if you're paying them by the hour, and if the work they are doing is something that you're doing all the time, and then it sounds like they may be closer to an employee status than an independent contractor. You may be walking a little bit too close to the fire there, or too close to the line.
Oh, thank you so much. The kicker is here, something you mentioned that really is not on the IRS website, and that is that before we had this, quote, independent contractor, we had a regular staff person doing this job. So this person was brought in because I had to terminate somebody's employment. And this is a dispute between me and my board, so I'm trying to walk really carefully here.
Sure.
I just feel like I can't guide them wrongly, and this person, when you take the place of a regular staff person and it's an essential function to the organization, I don't see how that can be an independent contractor.
Yeah, I think that if this is going to be an ongoing position, it's not one that's going to end in a couple of weeks or months. It's not just a very short-term thing, but it really is someone who took the place of an employee, and other than the way in which they're being paid, is really performing like an employee, right? Is working under your close supervision.
Walks like a duck and sounds like a duck. It's a duck, huh?
It's probably a duck. There you go.
Thank you so much.
You're very welcome.
Very helpful.
Let's see. This is Melanie. This isn't in the chat. Someone sent me in a message here. It says, "What are the responsibilities of employers when a center has a consumer that might verbally or sexually harass a staff member?"
Right. So that's a great question. What if a consumer, what if a client or a service recipient of an organization commits harassment? Well, an employer does have a responsibility to provide a reasonably safe workplace. However, there are going to be some situations where consumers or clients of organizations are going to be from time to time abusive, and it may be due to any number of factors, and it may be impossible to avoid that altogether. So, and also organizations are in sometimes in an environment where you cannot refuse to serve somebody. It's not that you can, conduct must be very egregious before you could remove somebody from the organization or remove them from eligibility. So this is definitely a tricky issue for independent living centers, without a doubt. I think there are a couple of things to keep in mind here. One is that I would just urge you to be in close contact with your staff, to let them know that you are concerned and committed to their safety, and you want to know of any abusive conduct. And by a consumer, you want to know about it, and you want to do whatever you possibly can within the confines of your operations, of your rules and policies, of your funding requirements, etc. And so I would always be sympathetic to a staff member who feels they've been abused by a consumer, and I would talk to them about if there are some steps that they would like to see happen, if they have some ideas about how to protect their safety and well-being. But this is a very, very delicate and tricky issue. And I've worked with staff members of a huge variety of organizations where staff are subject to some abuse by clients who are suffering in one shape or form, or acts of harassment or abuse or even violence, and it's almost inevitable that those things happen from time to time. It's impossible to prevent them due to the nature of the clientele, the mission of the organization. So I would think about doing whatever you can to prepare your staff. I mean, if you've had events like this happen in the past, it's always good to reflect on what's happened in the past and kind of use that experience wisely and be thoughtful about that experience. And then, of course, after an incident occurs, might be a good idea to bring staff together to talk about it, to share their ideas on handling this, and also, of course, share the importance of not reacting violently in return, not retaliating against a consumer, reinforce the values of your agency and some of your own key rules, that no matter what a consumer has done, there are certain things they must never do in return, but they always have that opportunity to come to their supervisor to share this information, to seek advice, to offer suggestions. So it's that two-way. It's not really even an open door policy. It's really more making certain the lines of communication are open so your staff feel that they can come to you, not only if they're actually subject to abuse or harassment by a consumer, but if they're fearful. If they're fearful for their safety, they should know. They need to come to you and talk to you about that, and you need to work with them to see if there's any way to make them feel more comfortable and to address that wrongful act.
Thank you, Melanie. We have a couple more questions, but let's save them for the end. I think we need to get back to the presentation.
Okay. All right. I can kind of see the questions are good ones, so we'll try to move right along so we can get back to them, because I would love to answer those. All right. The next topic on our agenda is workplace bullying. And this is something that we're becoming more and more aware of as we become more aware of bullying in the general population and certainly in our schools. We're becoming more aware of this whole issue of bullying. And, of course, bullying can happen in an office environment. Bullying may not actually be illegal conduct if it's not directed at a person because they're in a protected class, because of their sex, because of their race, etc. Workplace bullying may not be illegal, but there's no question that it can cause significant damage. And in one recent case, I've just listed on the slide in front of you, the Indiana Supreme Court upheld a verdict that was given by a lower court in a lower court trial, a verdict of $325,000 for someone who had been victimized in the workplace, and the damages were awarded for intentional infliction of emotional distress. So you can kind of imagine how being bullied at the workplace would cause that distress, and some courts may be open to a claim. So there is that possibility, although there's no specific law that prohibits workplace bullying. So I've given you a definition on the slide we have in front of us now on workplace bullying. And this is from an organization that works on this issue, and it was founded by two individuals who feel very passionate about this issue, and I believe one of them had some history of being mistreated in the workplace. So this is a definition that this particular group, the Workplace Bullying Institute, has come up with, and they refer to it as repeated harming mistreatment of one or more persons by one or more perpetrators that takes one of the following forms. It could be verbal abuse, offensive behavior, work interference, including sabotage, which prevents work from getting done. So bullying could be mistreatment of one or more persons by one or more perpetrators, and it's everything from verbal abuse to actually interfering with work. So you can look into that a little bit more if you're interested at the Workplace Bullying Institute website. All right, on the next slide, I just try to contrast a little bit bullying versus harassment, which we've been talking about today. Bullying is a form of harassment, but it's not necessarily illegal. It's not prohibited under law. And the second bullet point just reminds us that discriminatory harassment occurs in perhaps 20% of workplace bullying cases. And again, this is a statistic from the Workplace Bullying Institute. This organization also tells us that the majority of bullying is same-gender harassment. So there's another way that it contrasts with traditional sexual harassment, which tends to be harassment committed by one person against a member of the opposite sex. And apparently the victims of bullying do report serious health effects. And, of course, this is what adds to that price tag for workplace bullying. Now, there is legislation that has been proposed but not adopted in 17 states that would make it an unlawful employment practice to subject an employee to an abusive work environment via bullying. And, of course, this would make it actionable. I can't tell you. It's hard to predict whether this law will be adopted in the near future, but I will say that awareness of bullying is just growing at such a rate that I'm starting to hear from people that, there's a bully in the workplace, or I was bullied at work. I mean, people are even starting to use that language. Now, in terms of legal risks, an organization does have responsibility to provide a safe workplace under the Occupational Safety and Health Act, which is also called the OSH Act, O-S-H Act, under the Occupational Safety and Health Act's General Duty Clause. So you do have a basic responsibility to provide a safe workplace. Of course, when this law was adopted, the adopters were thinking safe workplace. They were probably thinking about environmental issues and safety related to the equipment that you're using and the air that you breathe, etc. It's hard to imagine that they were thinking about workplace bullying, but now that's certainly an issue that could be construed as, coming under this law. And you could also be held liable for negligent hiring. You could face a negligent hiring lawsuit if your organization were to hire someone who you knew or should have known, had you undertaken the proper due diligence, had a propensity to bully. For example, if you hire somebody and during the reference check process you find out that they were fired from their last job for bullying various employees in the workplace and causing those employees to be fearful, and you hire that individual, you say, well, something about that doesn't sound quite right, or I'm desperate and I really need somebody to do this job. Should you wind up hiring that person and they commit an act of violence or harm in your workplace, the victim could bring a claim against you for negligent hiring, that you were negligent in your hiring process. And then another potential tort that you face, or a tort exposure, is the potential for a claim alleging negligent referral. if another employer contacts your agency and asks for a reference on an employee that committed acts of workplace bullying and was a workplace bully, and you have documentation of that effect and caused people to be fearful, and another employer calls you for a reference and you don't mention anything about that. You leave that off. You don't say anything because perhaps your policies on reference giving are limited and you don't normally give information about somebody's performance. If you fail to mention that somebody was violent, had a propensity for violence, threatened violence, and that person goes off and works somewhere else because of that neutral reference, then that other employer could bring a claim against you should they suffer some harm as a result of the actions of that bully. So there are all sorts of potential potholes, if you will, in this area that we need to be paying attention to. So my next slide offers some practical strategies to minimize the risk of workplace bullying. The first one is that I do encourage everybody to try to conduct reference checks during the hiring process. Learn as much as you can about the people that you're bringing into the organization, and certainly ask the question of those who you contact for references whether they know of any reason why that applicant would not be suited to work in your independent living center. Right? If there's any reason why they have any pause to place that applicant in a position of responsibility in an organization like yours. We've already talked about having appropriate policies, clear policies, plainly worded policies concerning workplace behavior. So that's another strategy for minimizing the risk of bullying. I highlighted on this slide prompt investigation of complaints. Do make certain that you follow up any complaints, that you take all complaints seriously, and you do your best to, in a timely fashion, determine whether the complaint has merit, whether there's something to it, and then determine what action is appropriate based on the circumstances. And then another strategy would be to consider training and conflict resolution, and of course always hold staff accountable. They should know what your rules are, and they should be responsible for following your rules. All right, our last topic for today is workplace violence, and we'll spend the rest of our time on this and leave a little bit of time for the remaining questions. And this definition of workplace violence, which appears on the screen in front of you, is actually from the Centers for Disease Control, and it's back from 1996. But this is a definition by the U.S. government, and they define workplace violence as violent acts, including physical assaults and threats of assault, directed toward persons at work or on duty. Now, keep in mind that workplace violence could be everything from harassment or bullying to murder, to really serious harm, from emotional harm to, all the way up to physical harm and everything in between. All right, so some of the risk factors that may exacerbate your risk of workplace violence, increase the chance of an incident of workplace violence, are listed on the slide in front of you. The first risk factor, well known in the social services world, is working with volatile clients. When an organization has clients, or some portion of its clients are volatile, then an incident of workplace violence becomes a greater risk. Organizations that are very thinly staffed probably exacerbate their risk of workplace violence, where you don't have enough staff to do the work required, and if the work is stressful, then frustrations rise. It becomes harder to keep good people. You may be making some tough hiring decisions where you're bringing some people on who perhaps aren't well suited, but you're in a pinch or a bind. Workplace violence incidents actually increase when an organization offers transportation services, when transportation is part of its operations, and part of that reason is just the act of transporting somebody can be very stressful, and driving is stressful, as those of you who drive well know. And studies have found that people that are relatively calm and serene and not prone to anger sometimes get quite angry when they're driving due to what the events and circumstances they're faced with while out on the road. And another risk factor that exacerbates the risk of workplace violence is lack of staff training, where staff don't know what to do, how to do it. They may be frustrated and may lash out at consumers or at one another because they just don't know how to do the jobs they've been asked to do. On the slide that we've got in front of us now, I'm just reminding you that violence in the workplace is both a safety and a health issue. And the second bullet point is a bit sobering, that the most extreme form of workplace violence, which is homicide, is the fourth leading cause of fatal occupational injury in the U.S. So when you think about all the reasons or the ways in which people die in the workplace, homicide is fourth on the list. And in 2009, there were 521 workplace, a little over 4,000 fatal work injuries. That's a large number of people who were killed at work, who were murdered at work, 521 in 2009. Now, on a positive note, to go from some kind of sobering statistics, turning our attention to the fourth bullet point on this slide, the positive information or the positive news, upbeat news, is that the total number of murders or workplace homicides in 2009 was actually the smallest annual total in all the years that the census program has been collecting this information. So the numbers are down, and I think you are seeing serious crime rates down in communities across the country. I've read quite a bit about that lately, but here we are seeing a number where in the workplace these fatal work injuries have also gone down. And if I were to be asked, what's the reason for that, I would have to say that part of it is awareness, that employers are just more aware today than they've ever been before about this risk, and they're doing things to try to identify individuals who might represent a threat, and they're taking threats that employees make more seriously. They're taking action quicker, trying to be more sensitive to those warning signs. So of all the fatalities in the workplace, 3% were in 3% of the total were in healthcare and social assistance organizations. So somehow I don't think the math in that last bullet point is quite correct, but it's 3% of the total. So obviously, homicide in social services and healthcare organizations are not the majority of the homicides committed in the workplace, but it's still a significant number. All right, the next slide reviews some steps for managing or some tips for managing workplace violence risk. First and foremost, I think having a policy in place, having a clear statement that you have a zero tolerance for violence in the workplace, for threats of violence or actual violence. Again, you should have a no retaliation policy, the second bullet point on my slide. Ensure that no employee who reports workplace violence faces reprisal. Once again, like you did with your anti-harassment policy, you should encourage employees to report on a prompt basis any incidents, anytime they observe workplace violence or feel threatened and are fearful of workplace violence. And then the last tip on this slide is that you provide some training or the opportunity for employees to share their experiences with techniques to recognize someone's escalating agitation, to detect aggressive behavior or criminal intent, and what and how employees should respond and react when these things occur. So I think having on-the-job training, encouraging groups to come together to talk about this issue, to vet their concerns, is important. Now, when we look at a policy prohibiting workplace violence, there are some key elements that I wanted to just remind you about, and this is consistent with our prior discussion of sexual harassment and looking at some core components of a good policy. The first is your zero tolerance for violent, abusive conduct, threats of violence, or violent language. The second component that's key is requiring that employees report either suspicious or unusual behavior that put themselves or put others at risk, or that could put others at risk. And the third is some emergency procedure if there is an act of workplace violence. What will you do if there's an act of workplace violence? And I think it's important that employees know what your plans are, what you intend to do. And that will give them comfort as well. Another component of your workplace violence policy should be the designation of the personnel who will be responsible for investigating complaints of violence and who are going to be in charge in the event of an emergency. So, again, that gives everybody comfort that you have somebody identified who will be in charge. Another possible component of a policy would be to screen applicants for past criminal conduct that may render them ineligible to serve. Now, this isn't to say that everybody with a criminal history is ineligible to serve in your agency, because that may not be the case. But if you are looking at a screening policy, and trying to incorporate criminal history background checking, then one thing you have to give consideration to is what prior offenses would render somebody ineligible. You have to come up with this disqualification criteria before you start. I'm a big believer in the fact that there are very few agencies where any criminal history would render you ineligible to serve. For most of us, it's only certain types of offenses that would render somebody ineligible to serve because of our mission, because of the work we do or the clients we serve. And then I think it's important to preserve your right to review employee emails, voicemails, and computer files, certainly anything that's developed using your equipment and systems. The next slide just goes over some ideas for undertaking what I call this workplace violence security analysis. This is basically trying to understand your risk of an incident of workplace violence. I want you to be thinking about, for example, what environmental or operational risks exist that could lead to violence. Is there anything about our facility design that makes it more or less unsafe? Anything about the services we provide, anything about the circumstances facing our consumers or our employees. Take some time to reflect on past experiences. Has anything happened in the past that suggests we're at greater risk of workplace violence? What things have happened in the past that can help us understand this risk better and help us prepare to deal with it should it happen or prevent it from happening in the first place? And another thought here in doing this analysis or planning is to think about maybe doing an employee questionnaire. And a questionnaire might ask if an employee has been threatened or assaulted in the past, whether employees are aware of other crimes occurring at the organization, and whether they're aware of individuals carrying or using weapons. So just a little questionnaire to get a sense of what are folks' feelings about the safety of the workplace. And in doing this security analysis, I think what you're going to wind up with is what I'm showing on this next slide, and what I call the end result is that you may be able to identify some existing security measures and things you're already doing. You'll be in position to evaluate whether folks are familiar with your rules and safety protocols. You might be able to identify the need for some new things, new controls. I've worked with organizations that have installed panic buttons when they have staff that are concerned about their safety, and they're in one-on-one contact with consumers or clients, and they really want a way to be able to alert somebody that they need help without alarming the client in the process. Something as simple as improving the lighting, to adding mirrors in hallways and such, all the way up to probably the most expensive option, which would be the video surveillance equipment. So another option would be to identify the need for additional training or even the fact that you may need to update some policies. All right, my next slide has what I'm calling key steps in the wake of an incident of workplace violence. And this is basically just a reminder of things that you absolutely want to do and focus on should there be help victims, to report an incident to the police, that you try to secure the premises, and of course that would be in concert with the police, that you prepare an incident report. You certainly want to document what happened, when it happened, who was involved, and if it's a serious incident of workplace violence, you would absolutely want to consider whether some crisis counseling or any sort of critical incident stress debriefing is required for your staff and for your clients. All right, this next slide just reviews some thoughts in terms of safety training, make certain that your staff are aware of security hazards, and also procedures and ways to protect themselves. You always want to clarify your policies and make certain that people know how to report incidents, and also that they will be held accountable if they don't follow your policies. Make certain that you're using the security measures you've got installed, and that people understand why, not just what. We talked a little bit about this earlier. Folks in your organization need to understand, why you have these policies in place. And always encourage that two-way communication so that your staff are coming to you and telling you of their concerns and worries and fears so that you can consider what appropriate action should be taken. And when you undertake training in this area, make certain that whoever you bring in to do the training really understands the nature of the work you provide and those specific and unusual or unique circumstances in your environment that could contribute to this risk. This next slide just reviews some record-keeping basics, the fact that you should keep a log of work-related injuries and illnesses using OSHA Form 300, that you may need to have medical reports of work-related injuries and reports of certainly of any assaults, records of incidents, documentation of safety meetings, and of course record of safety training provided. So these are all just kind of good things to do in terms of closing the loop on any incidents. And if you keep good records and if you kind of remember to do these things, you're going to be in the best possible position to learn from even unfortunate circumstances that occur in the workplace and prevent future incidents and be better prepared for anything that might happen in the future. You really are in the best position to learn if you've taken the time to reflect and review. And this next slide just reminds us that in terms of leading an organization and managing an environment where there is that risk of harm, of violence, of harassment, just a reminder that the staff of your organization are far more likely to subscribe to your policies, to follow your policies, be supportive, and be held accountable when we have the same thing, that something will happen if they complain, if they come forward and report some fear or concern or incident, that something indeed will happen, that retaliation will not occur simply for reporting, that the process is sound and has integrity, that it's not just on paper only, but it's real, that the organization is really committed to the process, and that they're expected to participate, that their management staff and peers expect them to be part of the solution and fully participate in the process. And on the next slide, I've just listed a website where you can find some additional resources on workplace violence. It's at a subset of the OSHA.gov website, so I'd encourage you to take a look at that at your convenience.
That brings us back to the questions and answers. Do you want to run down the list, Melanie? Or
Okay, so I'm going to go back to the chat. Okay, the first question is from Amy Burns. Is it okay for an agency to require the employee voicing a complaint to submit it in writing before taking action? Very, very interesting topic and different points of view on this question. My own opinion about this is that you should not do anything to make the submission of complaints onerous. Don't make it difficult for people to make complaints. The reason is that if you make it difficult for people to complain, you will get fewer complaints. Well, part of my brain says, well, that's a good thing because I don't want to get a lot of complaints because I don't like complaints. But the reason it's a bad thing is that complaints are an early warning system. They give you a heads up about things that may not be going as well as you'd like, and they give you an opportunity to intervene and protect your organization. And so a complaint is a good thing. A complaint is something that's brought to your attention that you can evaluate what action to take. And if you require people to submit things in writing, you may lose people who say, well, in that case, I don't want to be bothered. I just wanted to tell you something that really worrying me and upsetting me, and I just don't, I just don't want to put it in writing, or I'm fearful about putting it in writing. Now, if someone comes to you with a complaint and they're hesitant to put it in writing, or they don't want to put it in writing, then you might offer to do it for them and say, well, you tell me what's going on and let me take some notes, and then I'll read it back to you and summarize it for you, and then it therefore becomes your complaint. So my take on this is not to require people to put things in writing. Now, I can certainly understand if you feel like you're subject to a slew of offhand comments and casual remarks, and all of a sudden these have to be treated as complaints, and you're trying to reduce the number of complaints by getting it in writing. I certainly understand that issue, but unfortunately when you force people to put things in writing, or you require that it be in writing before it's even considered, then you reduce the number of complaints you get, and you may miss some of these opportunities for early warning signs of things that really aren't tragic or hugely consequential, but do require some action. So I would suggest that you not do that. Is it legally okay? It is legally okay. There's no law that says you have to, accept verbal complaints. But I just think it creates this barrier that winds up reducing the number of complaints you get, and it reduces the number of opportunities you get to find out what's really going on in the workplace. All right, the next question comment is, CILs have the right to provide services to whomever they wish as long as it isn't discriminatory. Develop a policy that is approved by the board that staff is to be protected from abusive treatment from consumers. Consequences for such treatment will cause the consumer to lose services. That's an excellent comment, and I really appreciate that. So this comment is that you do have the right to limit services and exclude from eligibility somebody who's abusive. And so it is a good idea to make that full commitment to protecting your staff, and you're not required to continue serving somebody who's abusive. And the best way to probably remove somebody from eligibility is to show that they have violated your policies. And so if you've got the policy in writing and it's very clearly stated, you're going to be in the best possible position to remove that person. The next question is, in our experience, most potential employees provide references that will provide good information. Do you have a suggestion on how we can get a very candid reference check? I do have a suggestion. I think most people do provide references that they hope or expect will provide useful information. I think that you should, on your application form, one technique is to get permission to check and verify any and all information on the form. And so definitely if somebody gives you the name of somebody that they used to work with, but it doesn't appear that person was the direct supervisor, that you should call the direct supervisor. Another thing you can do is when you're talking to that reference, you could say, is there someone else who worked with this person I could talk to? Or could you tell me the names of some other people the person worked with that I might follow up with to contact? So you might actually be able to attract a couple of extra references who have not been pre-selected by the candidate. Here's my other tip. My other tip is that when you're asking these reference questions, make certain that you've crafted a really compelling question that goes along the lines of this. Do you have any reason to believe that placing this candidate in a position of care for our clientele would expose our clientele to danger of any kind? So that's just one way to word it. That's just one example. But come up with a question like that's really got some gravitas to it, that really says, do you know of any reason why it wouldn't be a good idea for us to hire this applicant to work with these very special consumers, or to work with these clients, to work with, just say it in a plain and simple way, have it rehearsed, and ask that question. And I think what you're going to find is that if you're talking to somebody who may love the candidate and have worked with them closely and felt good about them, they're going to have a really hard time lying to you and saying, no, nothing at all, if they have any concern. A question like that stops people in their tracks, and it is so serious that I think you're going to get some very candid answers. All right, the next question on the same topic of reference giving and getting was, how do we balance the previously suggested name, rank, and serial number type of reference to what was stated about liability for not divulging bullying behavior? Couldn't the employee file suit for sabotaging their ability to get a job? So this is a great question or comment. You're referencing not anything I've suggested, because we don't suggest that you only give name, rank, and serial number. That's what, unfortunately, some lawyers do recommend that you give, that you limit what you give. At the Nonprofit Risk Management Center, we strongly urge organizations to give more thorough references. And we think it's important that you give references, and that the way to reduce your risk of a defamation claim is to only give truthful, verifiable information. So when you're giving references on former employees, you're only speaking the truth. You're only sharing information that's in their file. So if their file says Melanie was terminated for being absent from work, for not showing up for work 4 or 5 days in a row without explanation, then there's no way I have any grounds for defamation by your speaking the truth. So truth is the absolute defense for defamation. Now, could an employee who is unable to get a job because you spoke the truth file a suit against you alleging defamation? Yes, the answer is yes. They could bring a claim saying that because of what you said about me, I did not get a job, therefore I forfeited an economic opportunity, I had an economic loss, and I have grounds to sue you. However, in your defense, you're going to show that all you did was confirm verifiable information, and that you don't meet the standard of defamation. You did not speak a false statement. You did not speak a statement with reckless disregard for the truth, and you did so in a responsible way. You weren't trying to spread rumors or hurt the employee. You were responding truthfully to a reference request. And so, yes, there is a risk of a claim, but I think there's some things you can do to improve the safety of your reference-giving practices. I think that's the last question, Tim.
I just wanted to know if there's any sample procedures and that you have to address bullying. So, for example, in our organization, we've had situations of bullying, verbal abuse in public, during staff meetings where people scream at each other and things like that. And that's like been a year ago now. How do you advise implementing, procedures? I thought maybe you could have some samples of that, but also do you have like any recommendations for an organization whose culture has in the past accepted that kind of behavior?
Right. Very good question. So the very first step I would say is to adopt a policy, a zero tolerance policy for bullying. And, there are many ways to do that. One is to just adopt a code of conduct. Many organizations have a code of conduct when they engage participants. In particular, organizations serving young people often have a code of conduct for the children. But I think it's important in this day and age to have a code of conduct for the workplace. And it may be just a one-page statement with some bullet points, saying things like, our organization, let me start with kind of a statement of purpose. It says, our organization is committed to having a caring, respectful, professional environment. It's something very clear statement at the beginning. And then I would follow that with, the following types of conduct are not permitted, are antithetical to our mission and our values and are therefore not permitted. Yelling in a loud voice to another employee, in an attempt to embarrass them. Using profane language in conversation with coworkers. Give examples of things that are not acceptable in your environment. And we have some tools to develop policies that we offer at the center, but this is the kind of thing that you can develop by just sitting and reflecting on it and then sharing it with other members of the management team and saying, what do you think? Have I covered it? Have I got everything? Are these the values we want to espouse? Is this the right intro statement in terms of our values and our mission, and are these the right things we want to prohibit? So don't make it overly complicated. Really just come up with a dozen or so things that are not permitted, and it sounds to me as though you've got past experience to base it on. Sabotaging somebody's work, not permitted. Using profane language, being threatening or intimidating, shouting, screaming, yelling at somebody in the workplace. I don't think it would take long for you to come up with that list. So that's the first thing. I would adopt the policy and get agreement, get buy-in, show it to a lot of people, and get everyone to agree, yes, this is how we want to operate. But you're right, we don't want to behave that way. It's a new day, and we're going to be a different agency. And then I would, perhaps convene a meeting where you have everybody in the agency, all the employees, to talk about it and tell them why you're adopting it and how it's all about improving the workplace, and have an opportunity for people to ask questions. And then, of course, let people know if you're ever subject to any of this conduct, please come see, and then name the person or the position that they will come see and report that to. So it kind of starts with thinking about what types of things you want to prohibit, putting them in writing in the form of a policy, and I think for you a code of conduct is probably the right tool, and then disseminating it and encouraging people to step forward if they experience or witness conduct that's contrary to the policy.
Thank you.
You're welcome.
Okay. Thanks so much, Melanie. I would love to continue, but we are out of time. Melanie, maybe I could do the same as part 3 and pass along some of these questions.
Absolutely.
Okay, great. I will organize them. So if you have a question that that we haven't had time to ask today, if you could send that to me, I'll collect the 2 from the public chat that we didn't get to. You don't have to resend them to me, but if you think of any in the future, you can email them to me at tim@ncil.org. I'll pass them along to Melanie, and we'll respond. We still need to send the answers from the Part 3 out to you all. We didn't forget about that, but we will do that too. So everyone, if you would look at the last slide here. If you're on the web, it's in front of you. If not, it's slide 39, and that's for the evaluation form. So if you would please fill out the evaluation form, and do remember that this is only for today, and I hope that you filled out the evaluations for parts 1 through 3. It's not too late if you haven't. If you have some notes, if you remember those, please do fill out the evaluation form. Let us know what you thought of today's presentation. Melanie, I want to thank you for an excellent job on all 4 parts of these. It's been a pleasure working with you and outstanding information. And I want to thank our participants as well. So thanks, everyone. Let us know if you have follow-up questions. Melanie, if you could hold the line, that'd be great. Everyone else, have a wonderful afternoon. Bye-bye.